Hello, welcome back to LBS Legal TV. My name's Stephen Carris. I'm joined by Chris Kirkblythe of LBS Legal also. We're all LBS Legal here. And our discussion today relates to personal injury law. And if you've been watching, we've covered a few rather serious points so far, which hopefully you'll have doubtlessly been making note of. Now, Chris, I know that LBS Legal regularly carries out regulatory audits on a lot of law firms. What, just as a matter of interest, would you say are the most common regulatory issues or concerns that are brought to bear?
Well, obviously, some of them I mentioned already, so I'm not going to repeat myself. But the types of the sort of the usual suspect breaches that we see time and time again. Obviously, let's start with the obvious one: breaches of the referral fee ban, or the ban of payments for referrals in personal injury work, contained in LASPO. I said that Jackson lecture would be 6 hours. Well, this would probably be 8 hours, but we are not happy with the majority of agreements that are in place between law firms and marketing companies. We don't think they're compliant. We think they carry huge risks. There are lawful ways of allowing a third party to introduce a person to you who wants to make a personal injury claim and paying that person. It can be done, but it's got to be done correctly. And in our experience, unfortunately, the vast majority of firms have made a complete hash of this. It's an area where there was a lot of dreadful advice around from lawyers who you would expect better from. There's a lot of appallingly drafted agreements being used, and then of course they get borrowed and adopted and used by another firm, and the whole thing's a mess. And not just the agreements themselves are a mess, but what we find equally as often is that the agreements are not a mess. The agreements are actually okay, but they bear no resemblance to what's actually happening on the ground. The usual one being that the agreement says that no information will be provided from the referrer to the firm, and you only have to look at 2 files or 1 sheet of telephone records or somebody's emails, and you'll see masses of information being provided. Okay, so LASPO, the obvious one. Also in terms of LASPO, these arrangements where various sign-up procedures are outsourced back to the referrer are very borderline and need to be structured extremely carefully. Something which is on the rise, litigation funding, a minefield, and we're seeing lots of litigation funding arrangements which are non-compliant or unlawful for a variety of reasons. Again, it's too technical to go into here. The old persistent issue of improper and unlawful data sharing with claims management companies continues. The flood of data going across and not being controlled and not being deleted correctly, and that whole area just needs completely sorting out.
I was hoping you'd mention that, actually.
I mean, most law firms don't even have the correct data sharing agreements in place with their, and certainly they don't have the right consents and the right permissions. So that's a very regular thing. Since the consumer contract regulations came into force, these are the ones that replaced the distance selling regulations and the consumers in a contracts made in a consumer's home, etc. regulations. Firms just haven't got their heads around that. Their cancellation notices are all over the place. They're wrong. They're not given in the right way, or they're not given at all, or they're out of date. And again, these are not trivial issues, because if a contract's not enforceable against the client, of course you've got the indemnity principle, which means that your costs are not recoverable from the third party insurer. So ATE, lastly, still a minefield. Who needs it? Do they need it? What should you tell them about whether they need it or not? How strong can you be in the recommendation that they take it? Should they take it at all? Can you get in trouble for advising them to take it, or for advising them not to take it, or for refusing to advise them at all on the point?
ATE after the event.
After the event insurance. And we've still got a residual category of ATE providers out there which are this is not so much a compliance point as an ethics point. There will be firms out there who know that they have got an arrangement with an ATE provider which will never pay out. these arrangements have been going for a long time. The Solicitors Regulation Authority has been woeful in its efforts to stamp this practice out. It's completely unlawful. It's actually criminality and fraud. And if there is anybody out there who has an arrangement with an ATE provider for essentially what are sham policies that never pay out and that are not intended to pay out, then my advice would be to those lawyers, don't continue with that arrangement. Get in touch with us, sort it out. Let's deal with it properly, and clean up your act. But then, of course, there's all this other category of lawyers who just don't know what they should be doing with ATE, whether the clients should be having them or not, or what type of policies. Again, can I deduct it from damages? Can I deduct all of it from damages? And what do I have to do to comply with the financial services scope and financial services conduct of business rules? Which records do I have to keep? What notices do I have to give to clients? And
this is
it's
all
all a mess.
Yeah. It's quite scary, isn't it? Really, but it's quite ironic that we're doing this show on Halloween, and so I think it's quite apt that we should have such a scary subject discussed. Woo!
Well, you mentioned that we do audits with law firms. That our average, and this is over a long period of time, so this is not a silly made-up figure. This is a figure based on substantial amounts of hard data. We identify, when we audit a personal injury form, on average 43 serious breaches of legal or regulatory duties. So, those guys who sat in that hotel and said this is a dysfunctional part of the legal profession, I'm not going to agree with them, because I'm a great advocate for, I know there's lots of brilliant firms out there doing great things, but, maybe they've got a point, because certainly I will go as far as to say that there are a lot of personal injury law firms, in fact the vast majority, who have completely inadequate systems for risk and compliance. And that's a massive risk, and they just leave it there, and they just hope that it never blows up in their faces, and they carry on making money in their practice as much as they can, as well as they can, and there's this huge thing just sat here which could just blow them into oblivion at any moment. And they just continue like that. And it's not satisfactory, because all you have to do is turn around and face that problem and say, right, how can I manage risk? How can I manage compliance? How can I get this stuff right? How can I make sure my CFA is correct? My approach to AT is correct? Let's build a system that does this stuff properly. And it's not that difficult. It just needs, a few days' attention here and there, a bit of outside support, and you can do it. And you can be safe. And you can protect your business, and you can protect your family. You just got to, brave up to it and do it. And really, that's our big message. Let's sort this out.
And would you say there are any other nasty things coming down the tracks that?
Well, would you like to guess whether there are more nasty things coming down the tracks?
I'm going to say yes.
You'd be right, Stephen. We have one or two things which are going to cause problems. Criminal Justice and Courts Bill, currently making its way through the House of Lords, due for a third reading on November the 10th. Couple of important things in there. One is a ban on offering inducements. Again, it's going to be a half-an-hour training session to explain how that ban will work, but it's been very cleverly drafted. It's very wide. I actually drove on the way into the studio past two signs in the windows of law firms, one in Manchester City Centre, one in the village where I live, offering inducements.
I know you did, because I drove you into the studio.
And and that is about to be banned. And along with it, various schemes will be caught, such as those firms who draft a free will for the person at the conclusion of their claim. There are all sorts of things, all sorts of complications that we need to get ready for. Perhaps more worrying and less in the press is in the same bill, I think it's section 56, there is this issue addressed of cases of fundamental dishonesty. And again, it's a half-an-hour lecture in its own right, but broadly speaking, if any aspect of your client's claim is fundamentally dishonest on a balance of probability, then the whole claim will be struck out by the court, must be struck out by the court, actually. And how this will work is that the court will look at all of the costs that the client is liable to pay to the defendant, and will deduct from that the damages for injury that the client would have received. So if the defendant's costs are £8,000 and the claimant is left with that bill, but there's been, for example, a dishonest claim for physio, then the entire claim will be struck out. The value of the claim will be assessed by the court, say £3,000. So you do £8,000 when it's £3,000, and your client gets a bill for £5,000. Now, okay, the bill is to your client, not to your firm. But of course, most clients are going to say, well, I was badly advised, I was wrongly advised, I was told to do this by my lawyers. There's going to be claims to the Ombudsman, there's going to be negligence claims, and there's going to be all sorts of difficulty caused. And, you know, we do see, I've got to be honest and say what we find. We look at claims and we find certain aspects of those claims that look just beyond belief. Often the claims themselves just look. I mean, just talking about the way that they look. Yes, okay. A bog standard whiplash claim, where the claimant then adds on the fact that they've been left with some kind of chronic pain disorder, which just doesn't make any real medical sense, but which claimant lawyers, if they're good, know is a nightmare for defendant lawyers. Or the client goes and gets 6 sessions of cognitive behavioural therapy. Now, bear in mind, all the defence are going to have to argue is that that aspect of the claim was dishonest on a balance of probabilities for the whole claim to be struck out, no costs to be recovered by the claimant lawyer, and a big bill for the client, which will obviously have ramifications for the claimant lawyer. So things like, unnecessary physio, unnecessary cognitive behavioural therapy, ridiculous claims of chronic pain, just purely invented. I couldn't work for 3 months.
Trying to flesh out the claim, basically.
Yeah. Now, historically, just that aspect of the claim would fail. So fine, not a big risk. Now it's the entire claim that's going to fail, with all of the ramifications of that. So, and I think so. That's one thing that's coming down the tracks is the Criminal Justice and Courts Bill. The second thing I'm going to mention is this whole issue of the changes to consumer credit regulation, which I know we talk about that a lot in this programme, and I know personal injury lawyers think it's irrelevant to them. It may be irrelevant, it may not, but what they need to know right now is, are they credit broking or not? How could they be credit broking? Well, by referring clients to credit hire companies. Whether or not they are credit broking, which that's all you need to know. Am I credit broking or am I not? And then if you want to make sense of that information, look at our previous shows. What it will come down to for most of you is get out the terms of business that the credit hire company use with their customers. Take those out and look for 2 clauses. And if these 2 clauses are there and are correct, then you're not credit broking. So the first clause is what's often referred to as a sunset clause or a determinant clause, which says that the contract will automatically determine on the last day of the 3rd calendar month. Because if that's the case, then it can't be a regulated hire agreement, because the definition of a regulated hire agreement contained in section 60N3B of the 2013 order is an arrangement which is capable of subsisting for 3 months or more. So look for the sunset clause. Is it there? If it is, great. Next, look for a qualifying clause which relates to the number of payments. And if you look at 60F of the 2013 order, if that's not clear, this is the Financial Services and Markets Act 2000 Regulated Activities Amendment number 2 order. And it's section 60F2, which makes certain credit agreements exempt because of the number of repayments to be made. So check for a clause which is consistent with clause 60F of this, which means that the agreement must be for a fixed sum credit, and the number of payments to be made by the borrower must not be more than 4. The payments are required to be made within a period of 12 months or less, and the credit is provided without interest or other significant charges. So if those 2 clauses are in the credit hire agreements, then what the people watching need to know is that they're not credit broking. I'm sorry to end on such a boring technical piece of information, but it is important.
No, Chris, don't apologise. I think it's very important, of course, that you don't hold back on these pressing issues. And of course, it's important.
I hope what we've demonstrated today is that running a personal injury law firm can no longer be considered to be an easy option or a straightforward option. It's a very high risk area, and it's getting worse all the time. It's getting more and more complicated. The financial modelling is getting more and more difficult. The money is getting more and more squeezed. The regulator attention more intense. It's worrying times, and firms need to smarten up and get to grips with this stuff, all of it, sort it out, and create a good platform for the future, because lots of claimant personal injury firms are going to fail. And that means that those who succeed are going to do very, very well. Invest in this stuff now. Invest in your business now. Get it right. Times could be great.
Food for thought, Chris, and some of you may already have indigestion. Well, that's really all we've got time for today. So thank you very much for watching us again. We hope to see you again on our next show, no doubt. What are we talking about next week, Chris? Do we know?
Well, it depends what the demand.
Okay, well, if you want to write in and you've got any suggestions for a topic that's very close to your own concerns, I was going to say heart there, but I'm sure that would be the wrong comparison. But please do write or get in touch, and please join us next week. Thanks again. Good night.